Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel and Elizabeth. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
Patent attorneys, inventors, and applicants are starting to notice that things at the U.S. Patent and Trademark Office are slowing down. First office action pendency, or the time from filing a patent application to receiving your first office action, essentially when examination begins, is up from fiscal year 24 to fiscal year 25 to date. The USPTO's stats show that pendency was 19.9 months in fiscal year 24, and now it's 22.8 months in fiscal year 25 through August, essentially 3 extra months of waiting. Part of this may be caused by changes in the examining corps, and it's expected that changes to telework policy will result in a further strain on this examining corps. So, unfortunately, companies in the semiconductor industry and other industries should probably expect delays getting their U.S. patents. But besides avoiding taking an extension of time when possible, what else can be done? We're joined by my colleague John DiMaio to talk about procedures at the USPTO to speed things up. John, welcome back for another episode. I know you've been here before to talk about USPTO policies and procedures, but could you give a quick introduction to yourself to start off?
Sure. My name's John DiMaio. I'm an attorney at Hodgson Russ with Nathaniel. I've been with the firm since 2016 as a summer associate when I was in law school. Prior to that, I did my master's and doctorate in organic chemistry from the University of Rochester in Rochester, New York. And now I'm a senior associate, happily practicing law in Buffalo, New York, and Rochester, New York.
John, it's so great to have you back again.
Thank you for having me. Happy to be a friend of the pod.
Exactly. We're getting our usual suspects, and it's fantastic. I'm just going to jump in here on our topic. So what's happening at the USPTO right now, and what is happening with the examiner corps?
So as I'm sure most of the listeners are aware, something big happened in 2025 on January 20th. As comes with every new administration, there are always changes that happen throughout the government. And in this instance, the beginning of 2025, there was a big push across the entire federal government to reduce staff and get rid of telework policies. The USPTO, for as long as at least I've been practicing law, has always been, most of the examining corps has been operating under a collective bargaining agreement that allowed them to have telework. And they had a collective bargaining agreement. It turns out that it looks like the collective bargaining agreement no longer applies to examiners because they were recently classified as working on objects of national security. So the CBA no longer applies to them. And aside from the reduction in force that happened earlier this year, where lots of people at the USPTO took the option to bow out and retire early, there is worry that examiners are going to be forced back to Alexandria. And at least all new examiners that have started this summer do not have the hoteling and telework policy. They've had to start their jobs in Alexandria. What makes this so particularly difficult is over the years, because examiners haven't been in Alexandria, the USPTO has been slowly but surely either leasing out buildings that they had, or the government's been selling those buildings. So there's really not a lot of office space either. So the big worry right now is that I believe there are about 10,000, and most of those are examiners. And as of, it looks like in February is about close to 9,000, and it's steadily been dropping. There are fewer examiners now than there were in 2024. And it's expected that if there is a return to office, that this number will further decrease, because the issue that's going to happen is examiners that don't live in Alexandria, unsurprisingly, they have lives wherever they currently live. They have children, they have families, they live in areas with lower cost of living. And there has been some resentment, and examiners that I've spoken to that have said, they, if forced to choose between moving to Alexandria or finding a new job closer to where they currently live, they're going to pick finding a new job closer where they normally live because the move is a big strain. And you can't do that to, it's one thing if you're a single person who has no ties to a particular area, there's less of a burden. But when you have children that have friends, when you have a spouse that has a job, there are other factors at play that may be more controlling than whether or not you want to keep working for the USPTO.
Yeah. And I think from other things I've read, John, that's true for the other satellite offices as well, besides Alexandria. I'm curious. I know I started off with a couple stats on pendency, but what do you have a better picture in terms of what is happening to pending patent applications, whether it's pendency or the unexamined inventory or other statistics that come from the official USPTO dashboard? I mean, what's going on based on some of these initial changes?
So all of this stuff is publicly available to start off. The website, you can see this is actually at the USPTO's website. It's uspto.gov/dashboard/patents. And what you can actually see is the patent data at a glance as of, I'm in August 2025, because the September data, at least at the time of recording, has not been released. And the first thing you can actually see is the unexamined patent application inventory, which includes all utility plant and reissue patents. And the data is kind of interesting because what you see, at least relative to where it was last August, the inventory is about the same. It peaked in January of 2025 with just shy of 840,000. And right now it's sitting at, the number as of August 25 is 800,559 unexamined applications. So that's what's sitting in the unexamined inventory. If I had to take a guess as to why it spiked in January, and this is just a guess, in January of this year, there was a new rule that was introduced that would require fees if you pay a continuation, if the continuation was greater than 6 years after its earliest effective filing date. And so I'm assuming, and again, this is just an assumption, that peak or that spike in number of applications was probably due to people trying to avoid that fee. I can speak from experience that I had contributed to that and specifically filed continuations before that fee hit because I didn't want to punish my clients for the slow speed of the USPTO necessitating they give them several $1,000s more. And so currently the total patent application inventory is about 1.25 million. So you have additional 450,000 applications that are being examined, whereas that 800,000 are not currently under examination. And as Nathaniel alluded to earlier, there is a rise in first action pendency. It dropped a little bit last year. I'm not sure if I would say it was significantly different than what it was in 2023. It was a little bit less, but it has gone up several months since 2024. So currently, the USPTO lists the timeline for the first action to be about 22.8 months. It's also sad. This reminds me of a previous feature that used to exist in EFS, RIP, that used to actually have a first action predictor that would tell you about how many months you would be getting your first office action or when you'd be getting anything in general, and that's long since gone. I don't know if it was ever really accurate, but it was kind of nice that it was there. One of the many things that have changed since the changeover in Patent Center. The other thing you can see with this statistic too is also the total, what they're considering is the traditional total pendency. So this is before, the amount of time until there's a final disposition reached, which is whether the patent's issued or abandoned. And that's currently sitting at 26.6 months. And so, what you can see from there is you've got about a 4-month difference. So either people are getting they're getting things allowed on their first action, or there's a single office action and then they're kind of cruising through. The number's kind of always been confusing to me. I struggle to make sense of it, but I know that number also does exclude RCEs that have been filed. So there's kind of a big asterisk with that. When you include RCEs, the timeline extends to about 30.8. So those are the current trends for now. if there is a reduction in force, it's likely that I would expect pendency to further increase in time, which will further be more expensive for applicants on the whole, especially if they have a robust continuation practice, because then they're going to be on the hook for paying continuation fees if they're 6 years or 9 years, after their filing date, which gets expensive quickly. So it starts to modify practice in a sense, because the question becomes, okay, do I wait until I have some idea of how prosecution is going before I start, filing cons and divs, or do I just, do it right in the beginning, knowing that I'm going to start breaking stuff apart? I mean, generally the way I tend to operate is I like to at least get a restriction on the record so I know what's being restricted out, so I at least can get safe harbor in a divisional. But, if money's tight, you may not have that luxury of waiting.
John, that was a lot to unpack. Thank you. Especially noting myself and my own company, this increase in fees for the cases that are more than 6 years old is definitely something that we've seen as an issue, as I'm sure everybody has. But I want to jump into something a little different that you didn't touch on, of all the many things that you did touch on there, which is Patent Prosecution Highway. So this was, I believe, the topic of this episode is like, how do we get things to move faster? You've talked a lot about why they are slower now. Is PPH still useful? Can you use it to keep things moving? And can you explain to our listeners, what qualifies for PPH?
Yeah. So PPH, it was a program that was initiated several years ago. So PPH is Patent Prosecution Highway. It's the fast track examination of patent applications. And essentially, what it allows you to do is, if you have a favorable office action or search report from a jurisdiction that participates in PPH, you can utilize that office work product and request accelerated examination based on that prior search from the other jurisdiction. In my practice, where I tend to see this, and we tend to utilize this in my practice by we, I mean me and the patent agents that I most frequently work with, it usually is for national stage applications, because what you can do is, if you get a favorable ISR/WO, what you can do is you can use that, map your claims that don't have inventive step or novelty issues, and get accelerated examination based on the search of that search report. And so this tends to get used pretty frequently. I'm looking at the statistics right now at the USPTO. So as of the end of July, this has been utilized about 100,000 times in the last year, or this is cumulative data, so total, and has 95,000 petitions. Of that, 104,717 have been granted. So it's got a relatively high grant rate to get accepted into the program. And the program's nice because it's the thing that all my clients love. It's free to utilize. So there's no fee to pay to use it. You fill out a form, you hope that the form is filled out correctly, and you kind of move forward. And you're always kind of on the hope that the examiner actually listens to or takes into account what you've presented. Because that being said, they will do their own search as well. Depends on the jurisdiction in the US. US examiners trust their own work. But yeah, so it's a very useful program. If you have the option to use it, I suggest using it if accelerating examination is of interest. And I know that's the goal of this podcast, but, or at least this particular episode. But sometimes, I have some clients where they want to drag out prosecution a little bit, whether it's for licensing reasons or some other reason. But if you're interested in accelerating it, that's the free option right now is PPH.
So besides using Patent Prosecution Highway to essentially move to the front of the line, let's assume you don't have a corresponding PCT application or another patent application in another country that you could get an allowance or a search report to throw in front of the USPTO with Patent Prosecution Highway. That narrows the options down a little bit. What about petition to make special? What do you need to show in order to get that?
So there are currently 2 programs under the petition to make special regime that are still in effect. You've got based on inventor age and based on inventor health. So if the inventor is greater than 65 years of age, you can file an e-petition, which is nice. You can do it right in Patent Center. So it's either granted or rejected immediately. And the other one is based on inventor's health. So if you have any sort of evidence that indicates the health of at least one inventor their health is deteriorating and the loss of that inventor may affect prosecution. I don't think you actually have to provide evidence that it would affect prosecution, but that's the idea behind it, is if the death of that inventor would be detrimental to prosecution because they would no longer be able to assist. So that is how you can utilize that. And so in that instance, I think what you file with that is something like a doctor's certificate or some other sort of medical certificate with it. When it comes to making special based on inventor's age, it says you can really include any evidence, but any evidence can just be a personal statement under penalty of felony indicating that they are 65 years or older. That being said, I think personally I've utilized inventor's age on at least one application. I don't think at least in recent memory, I haven't used an inventor's health. Have either of you guys ever used that in practice?
No, it's easier and requires less public information, I found, to do the age, because sadly they tend to go hand in hand. So, and it requires less of a burden of explanation to just say this person's over the age of 60. This inventor is over the age of 65.
Yeah. And there used to be some other programs that used to exist outside of these that were free that I'll, quickly mention because they don't exist anymore. And it's kind of a bummer that they're gone. And most of these were pilot programs that were set to expire anyway. There was no other reason besides that. When they have pilot programs, sometimes they opt to extend them. The one that most people are probably familiar with is the after final consideration pilot program, which I think sunsetted last year, I want to say, which was, I think, really, really great when it first started. And as it got closer and closer to sunset, it became less and less effective because at least in my experience, I was seeing an uptick in examiners just saying, I need more time to search, give me an RCE. And so, but the previous pilot programs that used to exist, there was the first-time filer expedited examination program. That's gone. So if you were a first-time filer, you could get accelerated examination and you had to qualify as a microentity. There was the cancer moonshot expedited examination program. That, I think, sunset at the end of 2024. There was the client change mitigation. Relevant to this podcast, there was a semiconductor technology pilot program that was supported under the CHIPS Act. There was the COVID pilot program. I utilized that a bunch during COVID when we had inventions that were tailored to either preventing infection or treating infection. And those were really good. And much like most of these programs, the goal was to always get you to a final disposition within 1 year of filing. So and that's to a final office action, whether that is, an allowance or goes into an RCE is a different question, but that was the goal. Right now, the big one that's left, and I think this is kind of a natural segue, is track one, which is the one that still kind of floats around. And so how I guess before I kind of start not pontificating, but ranting might be a better term. How often do you guys use this in your practice?
So I'm really excited for you to talk about this one, John, actually, because I went to a conference somewhat recently and there were quite a few people on stage talking specifically about track one and why they loved it and that they actually thought that maybe it was cheaper because you reached final disposition within a year. So it's something that I have really been thinking about. And I think, our other listeners should be thinking about as well. But I haven't had a lot of experience, like, we're filing them now, but we're not through the year, right? So I would definitely be interested in hearing your thoughts on that. And I do know, and I'm sure you're going to say this, that, track one, it costs money, right? If you have a nice old inventor, like that's convenient because you don't have to pay anything, right? Or PPH, is also free. But track one is a little bit of pay to get to the front of the line, I believe. So could you please tell us, how's track one work? How can it be helpful?
Yeah, so this is something that's done either after an RCE or at the time of filing. So when you utilize a track one request, it comes with a fee. If you are an undiscounted entity, it's shy of $5,000. Its exact fee is $4,515. If you're a small entity, it's $1,806, or if you're a micro entity, it's $903. And so much like with these other petitions to make special and previous pilot programs, the goal of this is to get you to a final disposition within 1 year. The tricky part with track one is that you have to be very careful when you prepare your request for track one. If you make any mistakes on the form, you get one chance to fix it. If you mess up that second chance, you're out of track one. There is no refund of money. All I can think of is that scene from the original Charlie and the Chocolate Factory with Gene Wilder shouting, "You get nothing, you go home." And so that's really one thing you have to be careful of with track one. The other thing is that you can't take extensions. So everything has to be within that 3-month period. And I think as long as you file the RCE, I think you still stay in track one. That's the one thing I can't remember off the top of my head.
Yeah, I was under the impression from someone, and this could be totally wrong, that you don't have to file an RCE, that the examiner just works with you even if it's more than, first and final.
That part I don't know, mainly because I've never run into that. I mean, usually if I'm utilizing track one, because the instances where people do this in my experience is more they've got something that's going to market very quickly, or they're in the midst of, some sort of licensing circumstance that dictates they get the patent extraordinarily quick. And so in my experience, it typically plays out like normal prosecution where, you get you get everything faster. So in the instance of the exact question that's used in the FAQ is, my application was previously granted special status under track one program at the time of original filing. I am now filing an RCE for that application. May I file another prioritized examination request with the RCE? So in that instance, you would have to file, at least my reading of this, you would have to file the prioritized permits a single request to be granted upon filing and a single request to be granted upon filing under an RCE. So anytime you hit the final and you enter where it would be an RCE, you have one chance to utilize it again. And I think if you get a second final that would necessitate an RCE, you're out of the program. That's my interpretation of it. I've always been fortunate enough to not have to think about that, because in those circumstances, we either get an allowance after the first office action, which is generally that's my preference in practice, is to get at least one office action. That way you've got an opportunity to amend, primarily because, I'm of the mindset that if I get a first action allowance, a no office action, it generally means that I left something on the table and my client is getting a narrower patent than they may deserve. Obviously, it could be I'm getting the exact right scope, but I would prefer to believe that I'm leaving something on the table. So I'd always at least like to have one opportunity to amend to make sure that scope is commensurate with what I think I'm capable of getting. And so it's either been granted right after that first action, or it's granted after I filed my RCE, and I've never wanted to go back into track one. And again, I think in the circumstance, it's again one of those situations where, does my client want to spend an additional, if they're a small entity, $1,800 on top of the cost of an RCE, which is $500 or $600 if they're small entity. It starts, on top of my attorney's fees for preparing a response, it starts to get expensive really, really quick. And so sometimes I think the way, at least I would anticipate some clients to, and of course there would be other clients anyway that may have a different opinion on it, is, they pay for it once, you've at least jumped the line by 2 years, right? So whether or not you stay in track one might not be a big deal, because generally, like, I'm still getting now and not accelerated or expedited prosecution. I think it's usually within 3 months I'm getting an office action following an RCE. So I'm not necessarily sure if it's worth, at least to my clients, I don't think it would be worth spending an additional $1,800 to get it a little bit faster, because at that point, once prosecution's moving, it's moving.
So all that makes sense. We have, as we've talked about, you have Patent Prosecution Highway. If you have something foreign, you've got petition to make special, depending on who is on your inventor list. You've got track one if you want to spend the money. Okay. Taking this from the opposite angle based on something you said, if you take an extension of time in any response, if you're in track one, you're kicked out of track one. You wasted your filing fee for it. Are there other particular deadlines or actions that you want to try to avoid to keep things going faster? I know I said at the intro that the obvious thing, if you want to get a patent faster, is don't take extensions of time. But are there other things that would slow you down, that would hurt more, that now that everything else is slowing down? What should you try not to do?
I mean, besides, super broad claiming, because that's usually the tricky part, especially after recent Supreme Court cases, particularly in my area, where genus claiming was kind of the lay of the land due to enablement issues. It's getting harder to get broader genuses, and so if you're unwilling to amend when you should to appease the examiner, that's just going to keep you in prosecution longer, which is fairly obvious. The other big thing is that we run into quite frequently is when people want to what fees they want to pay, when they want to pay them, and what they're filing at the time of filing, right? So things like declarations, filing fees, those tend to crop up. And it's hard too, because there are times in prosecution, when you want to speed things up, and then there are times when you want to completely slow things down for the exact opposite reason, right? I've had cases where it's, push, 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 and then suddenly an inventor to respond, they need a bunch of data. So it's trying to figure out, okay, what can we do to stall a little bit? And sometimes, that's a request for suspense, which I've never had to do, but I know is on the table. Sometimes it's a matter of filing a con, letting a case go, or not paying filing fees with the con to get a missing parts, which would buy you, 2 months of time to pay your, for free, or nominally free, because you have to pay the a fee for late filing fee, which is not it's under $200, and then plus the 5 months of extensions. So there's a lot of balancing, and it's always one of those things where it's like every situation is unique. If you're rushing, or not rushing, but like you want to get something done quickly, track one or PPH is really those are the two options that are most applicable to most people at any given time. Petitions to make special, much like the name implies, are special. Those circumstances are rarer, at least for my clients, because most of my clients, it's in terms of age, it's, the idea is, most people at 65 are probably retiring out of the workforce at that point. So how many inventors are, 65 and still working? And usually if, I've never, at least in, like I said, that I can remember, run into a circumstance where I've had to utilize petition to make special because of health. I know at least one of our colleagues has, but that was, he's been practicing for 20 years, and I think he's run into it once. Not to say that that's particularly any indication that other people may run into it, more or less, but.
So if there's this pendency that's, used to be 19.9 and is now 22.8 months to the first office action, if I file a continuation, which I guess I can really do at any time, should I do it earlier so that, even maybe before the parent case has reached, final disposition, so that some of that time that I spent waiting in line, was while the other one was pending, and then I can kind of like, jump in and get somewhere, sort of like when you go to Disneyland and you make the virtual line, and then you can go to lunch and come back. Or also sort of related to something else you said earlier, the 6-year fee, if you're claiming priority back to something that's 6 years old. If I'm getting close to that, should I file the con, prior to hitting that time frame to save myself some money? So I guess money and time, what do you think about cons?
Yeah. So I think if cons are of interest, I think I'm of the mindset that I think it's always good to have a continuation floating around, especially if you're in litigation, or, just you never know when you need a con, right? Especially like if you're a university, it's always great to if you have an issued patent, have a con pending, because it helps with licensing, because then you get a licensee, they know they can license that issued patent, but they have at least some skin in the game for the pending prosecution of the con. So I think you should always file at least one before the 6-year mark to avoid that new con fee. in terms of filing a con early, ignoring the 6 year thing and kind of dealing with pendency, I think it really depends on when you file the con. If you file it early, before an examiner has been assigned, I think, that might be useful, especially if you know right off the bat that you have things that may not be patentably distinct in a way that would be subject to a restriction, right? And you're going to be, prosecuting kind of different claim scope. It might make sense to do it there. My recommendation is typically, especially again in chemistry, it's always great to get the restriction on record so you can start filing divisionals instead of continuations. And I think the benefit you would see from pendency would be if it's done before an examiner is assigned. And the reason I say that is from like a social engineering perspective. And this is from talking to examiners, reading the examiner subreddit, seeing like what they're actually doing. Sometimes, after you get an examiner assigned, 90% of the time, you're getting the same examiner on the con or the div. And sometimes when examiners are looking for quick counts, they pick up the con because they know the case. And so if it's already been assigned an examiner, the pendency changes completely. So let's say you file the con after an examiner is assigned, it's going to take some time for the examiner to get assigned, but the likelihood of you waiting an additional 2 years, I think, drops. At least I haven't noticed it being as long in cons. I've noticed it being far less. And because sometimes examiners just pick it up because, like I said, it's an easy count, right? Because sometimes when you file a con, the client has not figured out what they want to claim. And so they file a con with the originally filed claims, or they file it with a single claim, right? And then if an examiner, it gets docketed to them, they look at the claims, they realize it's the same claims. It's a really easy 101 rejection, right? So they get quick counts. And I've had that happen where we had a case where the client did not want to, they were still trying to figure out claim scope. And within 6 months of filing the con, we had our first office action, which was shockingly fast. Not the fastest I've ever gotten an office action. I don't know if you remember this, Nathaniel, but I filed an application. It was probably like 2019. I got an office action in 2 months after filing. I think the issue, it was a brand new examiner. So I think that was a contributing factor in it. But I've only had that happen once in about 10 years.
I don't remember that specific one, but I can say that everything we talked about today there is general advice, because sometimes you're surprised and there's certain cases that you get an office action before it's even published and it makes no sense as to why. Sometimes you're waiting forever for it to get picked up when there's other things filed around the same time that have already granted. And sometimes, like me, this is something that I expect will happen more and more. I was getting ready to appeal a case, and as I was typing into the appeal brief with the examiner name, noticed that the examiner that has been giving me so much trouble is no longer on the case anymore.
Yeah, stuff happens. It's hard to predict like one of our coworkers has always said she sees something new every day, and she's been practicing since about 1999. And so it's something new every day. I recently had a case, and this one I think is really, really funny, where I filed a PCT and the application did not publish until after the international phase had ended, and I got the ISR after the international phase had ended. It was really bonkers. And it was one of those situations where I couldn't even, like, the ISR ended up being great, but I couldn't, like at the time of filing, like I was like, oh, I didn't think to file PPH because I didn't have a search report yet. And that was one of those circumstances where I've had something like that happen twice. And in both instances, it was because something got caught up in security review and it just never left security review. And it's one of those things where you don't necessarily think about, after you file a PCT, you don't think about it again until the ISR comes in and until the nationalization deadline comes up. You may not be thinking about, like, why didn't the ISR come in for this case? Like, sometimes you file the PCT and you just don't think about it until you get a notice from the USPTO or whomever your receiving office is. And it was one of those things where like 7 months, like it was like a year after I filed the PCT. I was like, I don't think I ever got an ISR in this case. And you start digging and you start making calls to the help desk to say, hey, what the heck is going on? But you literally never know what's going to happen.
It's always amazing to me, the new inventors that come to me and after we filed and they're like, so we're going to get the case in like, a month, right? I'm like, oh, patent prosecution is such a long-term project.
Yeah, I had the same conversation the other day. We were getting ready to file a provisional, like, oh, so when will this hit substantive examination? I was like, 4.5, 5 years from now. And there's kind of like you're doing it on Zoom or on Teams, and they kind of like pull their head back, like, out of shock. It's how it goes now. And it's, in some instances, like I said, there are always instances to accelerate prosecution because you haven't issued patent at the end of the day. And then there sometimes are reasons to drag it out. And there are methods that we can use to, achieve both of those goals. Just every circumstance is different and every situation is going to end up being different. And so it's pulling the right lever when you need to.
Well, John, thanks for explaining all the levers to us today and giving us a little bit of background of what's going on at the USPTO that is causing everyone to re-examine what levers are available for them to use.
Good pun.
Hope to have you again on the show to talk about some more procedures in the future, but thanks for joining today.
Thanks for having me. It's always great to chat with you guys.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.